Hi, I'm Jay from Strack, and in today's video, I'll talk about the worldwide laws that govern personally identifiable information. Personally identifiable information, or PII, is any information that someone could use to uniquely identify an individual. That may be a single piece of information, such as a government identification number, or a set of composite information that, taken together, specifies a single person. Many of the world's major governments have some sort of regulations concerning PII. A number of these are modeled after the European Union's General Data Protection Regulation, or GDPR. For example, Brazil's LGDP, China's PIPL, and the digital privacy laws in 4 U.S. states all follow the GDPR's basic contours. Each law both grants rights to the user and places obligations on companies doing business within its borders. The GDPR defines 8 basic rights. Key among these are the right to know. Consumers have a right to know what data a company has about them and how they intend to use it. The right to correction and erasure. Consumers have a right to request that a company correct false or outdated data. GDPR also protects the so-called right to be forgotten, i.e. a user may request that at any time a company remove all information regarding them from their systems. The right to data portability. Customers can request a copy of their data and are free to provide that data to other providers as they see fit. And finally, the right to object. Users have the right to file complaints about a company's decisions regarding data privacy without fear of retribution or reprisal. Note that these rights may differ by region. For example, Utah in the United States limits the right to erasure to data the user has directly provided to a company. These laws, of course, also impose obligations on companies. This is a complex subject, and these obligations will differ based on a company's size and its function. For example, whether it's considered a data controller or a data processor. In general, companies must treat data privacy as a consumer right, obtain consent for all data processing, respond to user requests, and demonstrate compliance to regulations. Techniques such as data mapping, which enables an organization to understand what data it has on a user, aren't necessarily enforced by law, but are more or less necessary to ensure compliance. Companies also, under GDPR and related regulations, must anonymize or tokenize sensitive user information, such as credit card numbers or U.S. Social Security numbers. How does a business comply with such a wide array of laws? Tools like Strack can help. Strack prevents sensitive information from leaking into your business productivity tools, such as Microsoft 365, Slack, and Zendesk. Such loss makes adhering to PII laws like GDPR nearly impossible. With Strack, you can prevent these losses from ever happening in an automated, scalable fashion. Visit strack.io today to book a demo and learn more.